Here on 24-1874 and 25-0628, Amy Rosteck versus Charles Davisson. Mr. Riley, you will be arguing for Mr. Davisson, and Mr. Preston, you will be arguing for Amy Rosteck. So whenever you're ready, Mr. Riley, we're ready for you.
Counsel, honorable judges of the Iowa Court of Appeals, if it pleases the court, I appear today on behalf of Charles Davisson in a suit over earnest money in a residential real estate transaction. This is not an ordinary buyer-seller dispute over earnest money. It's not that because, for whatever reason, Ms. Rosteck elected not to bring a declaratory judgment action and seek damages and declaratory relief over the right, but rather brought this as a replevin action. And I will talk sometime during my argument about the merits of the dispute as to who had the right. But before I do, I've always felt that this case really rests on the fact that with one unique and explainable exception, there is no case in American jurisprudence that has ever allowed a replevin action to get money in a bank account.
Is your position that in order to replevy money, it has to be basically specie?
Right.
It's got to be cash or coin of an identifiable nature. This bag of cash, these gold bars, this cash with these serial numbers on them.
Right. And I think there is language in the Pekin class of 67 case that might suggest that money in an account that was not commingled with other money might be subject to a replevin. Okay.
Well, what about if you have, like we have here, why doesn't the fact that you've got, and to make it maybe rounder numbers, let's say you had a $100,000 trust account and 10 people had each deposited $10,000 or had money deposited on their behalf into that to get to the $100,000. So even though we got $100,000 in there and we can't point to any, first of all, there is no specie to point to because it's just numbers on a piece of paper, basically. But if person A has 10,000 of that, if we know that because of A's account ledger, why isn't that specific enough to identify that $10,000 in that trust account to say, yeah, that's mine?
Well, the short answer is no American court has ever allowed it, with the exception of the Eaton versus Blood case that had unique exceptions. But the
nature of it, which is like a physical item to hold on to, is that?
I may be showing my age, but when I was a boy, I opened an account at Merchants National Bank, a savings account, and I got a book. And when I put money in, they made a notation. When I took money out, they made a notation. They obviously had their own records too, but yes.
You and I must be the same age because I had one of those as well.
And I'm not sure when that practice stopped, but you know, in Eaton versus Blood, there was number one, there was a passbook. Number two, the defendant in the replevin action admitted he had possession of all the items, but denied the right to possession of the replevin plaintiff. And so for both of those reasons, and
the second reason goes, the realtor acknowledged having possession of that money, right? Don't you?
Right, sure, but even so.
You've got Deposition Exhibit 5, which is the trust fund statement, as your little card that you got when you were a kid.
Well, no, the difference is the passbook is something you needed to take to the bank to get money out, whereas every commingled account is going to have records that are going to show what everybody's right is. I think that the reason, again, putting aside the fact that no court has ever allowed it, I think the reason is part of the historical nature of the replevin remedy. Keep in mind, this is a special action. There's a case, Justice McDonald, I think, referred to them as, in the Struve versus Struve, 930 Northwestern 2nd, 368, as statutory limited actions. But if you look at the Iowa Code It's Title, Roman numeral 15, Subtitle 5 is special actions. Everything that starts after probate, they're all special actions, and they all have a history in the English and American legal system, and the replevin action was historically an action to recover chattels. And that's one of the reasons why historically there haven't been any cases that have allowed the replevin of money in a bank account. Now, as I said,
You just cited to, Mr. Riley, you say Struve? Is it Struve? Is that the case you cited to?
Struve case, yeah, I'll just, and I can leave this with the clerk.
What was the cite on that?
I mean, like I said, I came across this recently, and
Cite on that?
it's 930 Northwestern 2nd, 368 at 376. I came across it in connection with something else, but I thought it was interesting because, special actions is what the code uses, and these actions are all for a specific purpose. Now, again, the Thorpe case does suggest that perhaps an account that just had one person's money that might be subject to a replevin, but they do specifically say, in other words, senior class money was commingled with hot lunch and other activities money and deposited in the banks. The class money was not held and deposited in a separate fund. And so that's the language that maybe shows if it was just in one account and nothing else was in there, it might be subject to replevin action.
The broker paid $100,000 over to Rosteck affect your analysis at all? Because that's actual $100,000 that went to her.
First of all, it went in the form of either a check or a wire transfer, but that was after they had, after the court denied summary judgment, and she was willing to put a bond, that's just an interim remedy, and so I don't think that an interim remedy can undercut the fact that this is not something that's allowed. I mean, keep in mind, I filed a motion for summary judgment 10 days after I filed my answer, because when I saw this, I thought a replevin action, I thought, I didn't think you could do that, and so let's just say it didn't take very long in the pulling open the annotated code and finding Tharp and all three of these cases, the Iowa cases. So this was no surprise. I thought I wanted to get it on there. I mean, counsel could have said, okay, maybe we've got a risk in proceeding with a replevin action if we can't recover money in a bank account, but whatever, for whatever reason, they persisted in that. But again,
move away from the replevin issue and talk a little bit about the contract termination notice. You're arguing it was not correctly terminated, but the buyer did send over this purchase contract release and disbursement of earnest money. Why is that not sufficient?
the contract calls for, when you can't cure title issues, it calls for a notice in 7 days. And this is just basically a proposal. Say, hey, would you be willing to give me the earnest money back? You look at the face of the form, that's what it says. And that's why both of Ms. Rosteck's experts made really clear that one said he wouldn't use it, the other said it's not really a very good form. It really doesn't, it doesn't give the notice that the contract requires. I mean, if you can't provide
Needed to say you've got 7 days from the date, business days from the date of your receipt of this notice to cure the title problems or give me my money back. Does it just matter if 7 business days pass without them doing that, when they said the reason I want to rescind is because you haven't cured the title problems once 7 business days pass? Is that enough?
I don't know. I mean, it would depend upon the circumstance of the case, but if you want to give notice of rescission, I think you have to comply with the contract, and the contract provides a very specific way to do that. So, and keep in mind, the lawyer for Green State said, well, we never would have released the lien. They'd released the lien once before. They'd released liens on other property. This was a judgment as a result of foreclosure of a company Mr. Davisson had, and he was a guarantor, so it was a personal judgment. She may have said that, but she might have been unhappy that he was able to confirm a plan of reorganization. And I suggest to you that if Green State Credit Union, let's see, this was $625 offer, we got about $225 on the first mortgage, I don't think they would have said no to $300,000 to $400,000 on their loan. And so the fact is, all of these things were curable. Although, again, she didn't give my client the opportunity. But again, that goes to the merits of the case, and I think she has problems there. But for whatever reason, you know, after fair warning, they persisted in pursuing a replevin action against a commingled bank account.
All right, thank you. You will have 5 minutes on rebuttal.
May it please the court, counsel. I'd like to begin by returning back to this issue of using replevin for money in an account. It's very important to recognize and to be careful about what type of account we are talking about. This was trust money pursuant to a real estate transaction. As questions have already noted, that made it subject to Iowa's administrative regulation, 193E-13.1 sub 6. And we 193E-13.1 sub 6. If you take a look at the final portions of that provision, it says very specifically what has to happen with trust money, and that is that it must be held not just with a journal and ledger entry, but in a separate ledger account. It uses that term, separate account. Now, and it must be segregated from all other accounts. It would be hard to conceive of a greater description of what is necessary to have the type of specific identifiability that the Iowa Supreme Court has 3 times acknowledged is sufficient to permit a replevin action within the state of Iowa. It fits hand in glove perfectly with the facts that we have here. And it was, in fact, indeed, a fact issue. This is one that was tried to a jury. Evidence was presented to the jury as to the nature of this real estate trust transaction, the manner in which these funds were held consistent with the Iowa Administrative Code, as I just cited it. That code section was, in fact, itself introduced as an item of evidence for the jury. The jury received evidence from Kyra Bell, the individual who oversaw this ledger account, to ensure that this money, this trust money, was held segregated at all times. She acknowledged that it was. That was evidence.
Question determined by a jury.
Not only determined by the jury, but the subject of a specific interrogatory number 1, which the jury found this money was and remained specifically identifiable. So the Iowa Supreme Court has said it is a fact issue. It is a fact issue that was submitted to the jury. The jury received evidence on that issue, unrebutted evidence, by the way, as the district court noted in its post-trial order. The only evidence the jury heard was that this trust money remained segregated and identifiable at all time. There was no contrary evidence submitted by Mr. Davisson on that.
Mr. Riley's cases, is he citing the wrong cases, or is he just interpreting them differently than you are?
He's citing the right cases. There's a trilogy of Iowa Supreme Court cases going back to 1926. They visited this in 1926, again in 1940, and again in 1967. Those are the correct cases. However, what Mr. Riley overlooks is that all 3 of those cases said in Iowa, money is subject to replevin so long as specifically identifiable. And in the Eaton versus Blood in 1926, the Iowa Supreme Court said that money in a bank account is subject to replevin so long as specifically identifiable. The passbook there was simply the manifestation by which the court found there was identifiability there. Also in that Eaton case, as Mr. Riley had noted, there was some discussion with him about this as to whether there is an admission that everyone knows what money we're talking about so that we can really obviate worrying about this specific identifiability. In the Eaton case, the answer of the defendant was, yes, we are in possession of the assets in this account. That was given in the answer. The Iowa Supreme Court said that whatever issues may exist regarding specific identifiability, they have now been admitted away in this case. If we contrast, or rather utilize that, in this case, I would commend to the court, as it sounds like you've already looked at, the answer of Golden Circle, that is the party that was holding, and the answer of Mr. Davisson. If you look at our allegations at paragraphs number 8, 15, 30, and 31 of our petition, we essentially lay out the fundamentals of this $100,000 of Amy Rosteck's money went to be held in this trust account. Demand was made for the return of that money, and it was refused to be returned. Those allegations were specifically, unequivocally admitted by Golden Circle and generally admitted by Mr. Davisson. He at least did not deny any of them, and in fact, in some portions of them specifically admitted. So what the Iowa Supreme Court has said really takes this out of even wrestling with the question of specific identifiability. That is, the admission by the defendant or defendants has happened here. In 1926, when the Iowa Supreme Court said what the appellant here says should have been earth-shattering news in the world of replevin, and that is that money held in a bank account can be the subject of replevin, that was met with the Iowa legislature doing nothing to change the Iowa's replevin statute. It is canon in statutory interpretation that if the Iowa Supreme Court renders a decision on a statute and the Iowa legislature does not change the statute in response, it is presumed that the legislature agrees with that decision as being consistent with the then written statute. Iowa's replevin statute has remained largely unchanged since 1860. So in response to this bombshell decision in 1926, 100 years ago, the Iowa legislature responded by doing absolutely nothing. When the Iowa legislature heard that the Iowa Supreme Court said, we think money in a bank account, so long as specifically identifiable, does fit within Iowa's replevin statute, the Iowa legislature for 100 years tacitly agreed with that and said that's a correct interpretation that we would expect. I want to move a little bit to the rescission question that was asked, and that is a bit of a red herring for a few reasons. Number one, the notice of rescission unequivocally was given. That is, the document that was provided, every bit of testimony was provided by all of the realtors and the attorneys in this matter, agreed that within the Cedar Rapids Realty area, that the notice of rescission that was given is the document. It says right at the bottom, Cedar Rapids Association Area of Realtors, and that was, everyone who testified in this matter said that is the document used by realtors in Cedar Rapids to rescind a contract. And
But I think Mr. Riley's complaint is it didn't notify the other side that they had 7 business days to cure the default, if you will. So what would have happened if, once that notice was given, what if they cured the problem 3 business days later, or 10 business days later, when the notice didn't say how much time they had to fix the problem?
the appellant cites to no language that says that one party to the contract is obligated to regurgitate the contractual language. The contract itself put the appellant on notice of their 7-day rights. It's not necessary for us to tell them again what the document says. It's necessary to give the notice of rescission and the reasons for that, and then within the passage of 7 days, had they cured, they may have had an argument. However, as the district court found to be very important in its post-trial ruling, Mr. Riley himself instead drafted a letter immediately saying, your notice of rescission, essentially your notice or attempt to rescind is rejected, you have to close today, notwithstanding the existence of these liens. So within that 7-day period, Mr. Davisson said, I'm going to bring this to a head. We're either going to do this now or we're not going to do it. And so any issues of 7 days is frankly academic. So that's one part of it. The other thing that's really important is that there were in fact 3 distinct bases by which this agreement was breached by Mr. Davisson, any one of which support the return of the earnest money. The only one that had a requirement for a notice of rescission was arguably the failure to provide marketable title. There were 2 additional bases found by the jury and upheld by the district court for the breach by Mr. Davisson, each of which would have warranted the return of the earnest money. The first is Mr. Davisson gave false statements on his disclosure. The purchase-sale agreement itself has language that says you must disclose material defects. So the purchase agreement incorporates essentially, implicitly by reference, the disclosure document. The disclosure document at questions 18A and 18B were both falsely filled out by Mr. Davisson. The jury found that was a breach of the agreement. The district court on its post-trial decision upheld that. That language, that portion within the purchase sale agreement has no requirement of a notice of rescission. So that was an independent basis. Additionally, Mr. Davisson failed to maintain the property in the condition as it existed at the time of the sale. That was an independent breach of the purchase sale agreement, independently supporting the jury's finding of a breach.
Grass and the dead plants.
Basis, yes, which we consider to be material. The realtors who testified considered it to be material. The jury found it to be material. The judge found it to be material. That was a breach that warranted the return of the earnest money, and the purchase sale agreement did not require notice of rescission for that. So for that reason, we would ask that the court uphold the finding of the jury in the district court. Thank you for your time.
Mr. Riley, before you start your rebuttal, can I have you start with the issue we didn't reach on the consolidated appeals, and that's the attorney fee issue, and your challenge to the reasonableness of the attorney fees awarded?
We really think, first of all, there were violations of the cost statute with respect to the depositions and the experts. I think the fees were unreasonable, given if you add the money they wrote off, they had twice as much of time, char that was incurred on this case than the amount in issue. And I agree that we have to find a way to train young lawyers, but I don't think my client should necessarily have to be responsible for all of the work of two lawyers in what was not really a complicated case. And so that's my feeling on that. And I would also say, I guess the argument is made that because we appealed it, we had asked the judge in resisting the fee agreement to defer action until everything was done, which I thought would have made a lot of sense, because then you can handle the appeal time, you'll know who's the prevailing party. And they're saying that apparently that wasn't enough to preserve error. I think the case we cited talks about, on fee issues, they ultimately decide at the end who's the prevailing party, and it probably would have been wise to wait until then. But I can see if you appeal the underlying case, but don't appeal the fee award, then it becomes a final judgment. You can't do anything about it, but we appealed it. So I just...
Reasonableness of the fees is you just think it's too much? Is that what your basis is?
Basically, again, we had two lawyers on what was not really a factually complicated case. And the legal issues, I don't think were that complicated. Again, we come back to, no American court other than Eaton versus Blood has held that. And the suggestion was, well, this bombshell case, well, it was a bombshell case. I don't know if...
Ask you a question about that identifiability issue, because I'm going to turn it on you a little bit, because if you, Mr. Davisson, wanted to get the $100,000 out of the trust account that was holding this sum, and you couldn't, and you contacted this trust group and said, hey, we want that $100,000, and they said, yeah, we really can't figure out where it is, wouldn't you be citing the Iowa Administrative Code Section 193E and say, hey, you're supposed to hold this in an individual ledgered account. I want my money.
Well, first of all, there are procedures under the code as to what to do in the event of a dispute. Secondly, if I wanted the money, the realtor is not going to release it unless there's a court order or an agreement.
Be held in a trust account labeled for this particular situation.
What I expect is that the account will have sufficient records so they can determine the ascertainable balance due everybody, and that there will be enough money in that account to cover it. But that doesn't mean it's specifically identifiable. That just means it's a commingled account that has money in it. We're familiar with commingled accounts, whether it's realtors or lawyers, but that doesn't mean that someone can go to our bank and say, I've got $10,000 in Riley's trust account, give me my money. First of all, the money in an account You know, when you have specie, and that's really what these cases are talking about, and I think that goes back to the historical nature of the replevin action, why they refer to, is it labeled, is it something like that? And in fact, that Florida case talks about, you know, what is the sheriff supposed to do when the sheriff, you know, is executing the writ, okay? Because what you have, you know, in a bank, you may have cash, but the instant you give it to the teller, you know, your physical asset, cash, now becomes an intangible personal property right, the right to get money out of a bank account. And I think what we're really talking about here is the replevin action remedy is not available. And to follow up with Judge Greer's question, yes, I would have said, you have this money, but if I felt my client was entitled to it, after a quick trip to the library, I wouldn't have filed a replevin action. I would have filed an action for declaratory judgment, which is a broad remedy that allows the court to determine everything. You know, these are special actions because they have a long history. And again, it was an earth-shaking case because the ALR, when this case came out, they had an ALR article. It's got an ALR designation. No case since 1926 has said that, including the case they cite from Indiana, which involved cash, not money in a bank.
Thank you, Mr. Riley. With that, we will consider the case submitted, and thank you, counsel, for your excellent arguments and briefing. And my colleagues and I will get a decision out as soon as we can. Thank you.